Seated. We are here now for the case of MIMG. Two separate cases. We'll have one oral argument. One case involves the respondent of Miller, and the other involves the respondent of Williams. I will assume the arguments apply to both unless someone alerts us otherwise. Thank you. Mr. Weinhardt, you may begin. And it's also my understanding Mr. Bigsby will be arguing for legal aid? That's correct. Yeah. Thank you. Go ahead, Mr. Weinhardt.
Thank you, Your Honor. May it please the court, counsel. This case asks whether an Emergency COVID Relief Act in a section that was expressly denominated as temporary effected a permanent and substantial change in state landlord-tenant law. The section in question is part of the CARES Act. It's at 15 United States Code section 9058. It did two things regarding residential properties connected to any of various federal housing programs. The first thing it did is impose a 120-day moratorium on evictions from those properties. The second thing it did is to require a 30-day notice period before an eviction action could be filed, such notice period not to start until after the 120-day moratorium had ended. That 30-day notice requirement conflicts with the familiar 3-day notice to quit requirement contained in Iowa's forcible entry and detainer statute. In two cases that are before this court today, the magistrate and the district court each ruled that more than 2 years after the end of the CARES Act moratorium, that 30-day notice to quit overrode the 3-day notice to quit in the Iowa statute. That was a misinterpretation of the federal statute, and it was an edict that the federal statute preempts Iowa's landlord-tenant regime regarding the 3-day notice to quit. I want to talk for a moment about the relationship between preemption and statutory interpretation. They occupy two different divisions of our brief, but they are really all part of the same argument. This is a statutory interpretation case. Preemption, however, greatly influences the process of statutory interpretation here. If there are two plausible readings of a federal statute, the Supreme Court has held that this court has a duty to accept the reading that disfavors presumption. This court's own jurisprudence in the Carroll Airport Commission case says that there is a presumption against preemption which counsels a narrow construction. Yes.
That for purposes of this case and statutory interpretation principles for this case, we should probably be guided by the U.S. Supreme Court and federal statutory interpretation law, or do we look at our own rules?
First of all, I don't think that there is a material difference between the two sets of rules in terms of how they influence the statutory interpretation here. Secondly, but to the degree that there is a difference, the Amicus Landlord Association cited to this court law stating that this court's power in interpreting federal legislation includes the ability to use its own precedents in doing so. So I think the court would be on safe ground in doing that.
Did 9058 preempt our FED statute during the 120-day moratorium period?
That is not a question this court needs to answer to resolve this case, but we proceed with the assumption that it did. The issue is the status of the 30-day notice period after the 120-day moratorium and the period after the FEDs that would have been filed during that moratorium had run out. Does the statute continue to impose a forever 30-day notice period after that? That's where the statutory interpretation comes in here, and that's where the command of the Congress is much less clear than it was during the actual 120-day moratorium.
Let me make sure I understand the interpretation you're advocating for. What you're saying is that the default has to have arisen during the moratorium. Is that what you're saying?
So, yes. The default had to arise during the moratorium, and then based on that default, if after the moratorium there is a notice to quit filed, that notice to quit has to be for 30 days. Once you get past defaults that accrue after the end of the moratorium, then we're back to the 3-day regime.
Language in 9058 C2.
The language in 9058C1 talks about the 30-day notice, and the language in C2 says that it is triggered. It refers back to the 120-day moratorium. There's nothing that disconnects it, however, from the moratorium. There's nothing that makes it a free-floating 30-day forever requirement. Instead, basically, the argument here from the amicus is that if you look at 9058 sub C sub 1, the fact that in that provision there wasn't a sunset provision written into it, that must be an expression of congressional intent that it lasts forever. And our argument is that Congress had to speak much more clearly in order to effect preemption.
Cases from other jurisdictions that have decided this same issue, at least the ones I found, have all gone the other way. Do you have any more? Are there different authorities that have come out in favor of the interpretation you're proposing since the briefs have been filed?
There is only one authority since the briefs have been filed, and it's not a dispositive authority, it's a concurrence. So there's a case, MIMG versus Ellis, that was decided by the Nebraska Supreme Court on May 31st of this year. And in that case, there was a concurrence by Justice Papik, and he made an argument that's not exactly the same as ours, but has essentially the same effect. His argument was that the federalism canon of construction that provides a very powerful presumption against reading something federally to intrude into an area of state law domain, that needs to be applied to the statutory interpretation process in these cases. And so basically, the same thumb on the scale.
Limited to the extent that, as I understand it, this law only affects properties that receive federal funding or support. So this doesn't change kind of purely private landlord-tenant law. Is that right?
Correct, except that first of all, the list in the statute, if one follows back through the references and references to beyond them, the list of all of the federal programs is tremendous. And the coverage nationwide is millions of units of housing are covered by these programs.
Let's say the apartment building had a mortgage and the mortgage is backed by Fannie Mae or Freddie Mac, then it's covered, right? And that could be a purely private building that it's not low-income housing, and otherwise it's participating in the regular private market for rental housing, right?
So it includes every manner of federal program that in some way supports the landlord's acquisition or administration of the property, and every manner of federal program that in some way supports the tenant's ability to pay the rent. And when those two things are combined, it winds up affecting an enormous number of all of the FED actions, because the federal programs are all intended to help access to housing by low-income people. Low-income people are the ones who have trouble paying their rent, and so those are the ones who then wind up being subject to FED actions. And so while this doesn't affect all landlord-tenant law in Iowa, in the realm where it operates, it has an enormous effect on landlords and tenants both.
For a second, Mr. Weinhardt. Your third issue, I'm just curious, looking at it from a practical standpoint, you've argued that the retreat was not aware of the possibility of dismissal until the magistrate unilaterally applied an isolated piece of expired federal legislation, and Miller was not there. That seems like a really big statement, but you didn't also say, and we did not order a transcript to say what was or was not said. How can we proceed on that third issue without a transcript?
I think simply based upon the written ruling and then the affirmance of it, it tells the court what it was that happened. And so I don't think there's anything more that needs to be there in the record.
How do you know? How do you know the judge didn't show or state something that would have not been shock and awe? I mean, I think that's an assumption you're making of what the record was or was not?
It may be an assumption. I'll tell you, our arguments here for reversal are much more focused on the statutory interpretation question and the lens of preemption that we look through. And so I'll concede it if the court wants. The point is, the statutory interpretation question and the preemption question that overlays it are things that create real problems for landlords and tenants every day, and this court has everything it needs to decide that question and clear the law up, at least here in the state of Iowa.
If we would give opposing counsel what they're asking for, what would that fallout be? I'm trying to imagine just how many FEDs we have every day across the state, every courtroom, every jurisdiction, but and what would the takeaway be?
So, first of all, it would result in every landlord giving a free month of rent to everyone who falls behind on their rent. But secondly,
Possession.
that's where I was going next, is that we have this real problem between the peaceable possession statute at 648.18 that is effectively a 30-day statute of limitations for filing an FED action, and the exactly parallel 30-day federal requirement for notice. And it's essentially impossible to comply with those things both at the same time.
That's Iowa's problem. I mean, assuming there was a preemption, they'd say, well, you know, go clean up your state laws then to work around our legislation. We don't have to preempt in a way that happens to be convenient to Iowa state laws.
But I think, Your Honor, that circles back to the question of, has Congress spoken with the clear and manifest purpose, or has it used the exceedingly clear language, those both from recent Supreme Court precedents, to say that there was preemption? And we don't think that that's the case. And that, I think, gets us to the statutory interpretation question here. Legal aid and the district court went astray by looking at a subsection within this statute and concluding by negative inference that because in those 40 words there was not a sunset provision, that Congress must have intended to hijack landlord-tenant law nationwide forever. The bigger picture of this is that the CARES Act was a response to a national emergency. The section that this falls under is under a subchapter that is entitled Economic Stabilization and Assistance to Severely Distressed Sectors in the United States Economy. Well, the distress wasn't permanent. The section title that this falls in is called Temporary Moratorium on Eviction Filings. Legal aid concedes that that word temporary in the title of the statute has force, yet argues, well, that just might mean that Congress might come back and fix it later. We don't determine interpretation, and certainly not preemption, based upon what Congress might do. We interpret it based on what Congress did.
Based on the words, and I haven't really heard you talk about the specific words. I know it's in a subsection, but those words are pretty important. Could you address the specific words and why? It seems like you're adding language to subsection 2 to caveat it, to say that it only applies to a delinquency that occurred during the 120-day moratorium. Can you explain to me why that's not the case?
I believe that subsection C refers back to the moratorium, and so the two are interrelated.
Back to it just to say that you can't issue the notice until after the expiration, the 120-day period has ended.
So
Why doesn't that mean there's a moratorium that went through July, whatever the date was, and then after that time, okay, now we can start doing 30-day notices. You can start doing notices, but they have to be 30-day, and there's not an end to that.
Because in subsection B and subsection C, they both refer in singular terms to the tenant. And so the two of them flow into each other. If the interpretation that is urged by legal aid were the proper interpretation of subsection C1, it would say tenants plural. It would say any tenant, but it doesn't. It refers to the same tenant who is the tenant who benefited from the 120-day moratorium in the previous section.
On that point, in the definition of covered dwelling in 9058 A sub 1, it says the term covered dwelling means a dwelling that is occupied by a tenant. Does that mean only a tenant that is subject to subsection B?
So in the covered dwelling definition, I think the point of that is to make sure that you understand that it is a residential property. It's not a garage. It's not a commercial building or something. It has to be an occupied structure, similar to occupied structures in a burglary statute or something like that. I don't think that that is trying to limit or expand the focus of subsection C1 in the same statute.
Split in authority in other states, whether the 30 days applies beyond just a default on the rent, but also other reasons for eviction, and how does that help us here?
I will be candid, and to come back to Justice McDonald's question, none of there are 4 appellate state cases that have ever been decided in this case previously. None of them applies the preemption analysis that we have applied, which is what I think makes them all distinguishable. I don't think that but I would have to read them carefully with this in mind. I don't think that they all expressly address the question of whether the statute reaches to violence or other kind of breach of lease evictions. The statute itself, if you read the words, says that it's supposed to be non-payment evictions, and amicus for the landlords are asking that we at least limit it to that, although I think much more relief is warranted here.
I'm going to be asking legal aid about this, so I'll give them a preview, but it seems to me you either read it as a whole or you read it in isolation. If you read C1 in isolation, then it applies to all evictions, violence, running a drug operation in the apartment, being a fire hazard to your co-tenants, all of those things. Or you read it, you let the other sections help interpret C1, in which case then you can say it only applies to non-payment of rent. You can't have 2 different methods of reading it.
Agreed, and we would say that what is necessary is to read the entire statute holistically in order to not just sort of carve C1 out and look at it with a microscope. And
Have you seen the Knight case from Court of Appeals of Washington, I believe, that has addressed the issue with when it comes outside of the rent context?
I'm not from, so the Washington case that I am familiar with is the Sherwood-Auburn case.
That talks about Sherwood. If you're not familiar with it, that's fine. Okay.
Outside of the non-payment of rent context. But the bottom line of this is that under settled law, whether state or federal, if there is an ambiguity here to this statute, the fact that we're talking about preemption makes this an easy case, and it means that we construe this in a way that avoids preemption. And there is at least an ambiguity in the statute when you look at it holistically. And I think the circumstances under which the statute was enacted need to be taken into account. This whole thing, this is the CARES Act. It appropriated more than $2 trillion, with a T, $2 trillion. It was enacted on March 25th of 2020. That was only 14 days after the World Health Organization declared that there even was a pandemic. It was 12 days after the United States declaration of emergency. It was 10 days after the first shutdowns of any meaningful public activity, for example, the New York City schools. This law was created at breakneck speed. And for us to now, years later, look at these 40 words and say that Congress drafted those with such care that we have to only look at those 40 words and not the overall context of the statute, I think is what led the district courts astray and what this court needs to correct.
On that point, we had a lot of orders that came out during COVID. And at the end of it, there were actually some things that we put in place that we liked, that we decided to keep. Now, we didn't keep those orders in place. We put those provisions in other rules. But couldn't we read this as Congress doing that? It's sort of saying, hey, we did this and now we kind of like it, so we're not going to change it?
I don't think that we find preemption from what Congress didn't do. In other words, Congress didn't amend it, or particularly the 118th Congress, and as dysfunctional as that was for the last 2 years. I think the way we determine whether Congress spoke so clearly as to create preemption is that we look at what Congress actually did. And what Congress actually did is create kind of a mishmash of a standard that at minimum is ambiguous enough that I don't think that you can find preemption there.
Court that's addressed this says it's unambiguous.
And every other court that has addressed this has failed to do so while considering at the same time whether or not it preempted local law regarding evictions.
Preemption override the unambiguous language used in a statute? The preemption analysis?
Analysis would not override entirely unambiguous language. I can't get to this being entirely unambiguous when the statute is viewed holistically. Thank you.
Thank you, Your Honor. May it please the court, counsel. My name is Patrick Bigsby. I'm here today on behalf of invited amicus Iowa Legal Aid. This case is far less complicated than MIMG would have you believe. The plain language and structure of the portion of the CARES Act at 15 U.S.C. 9058 sub c renders its meaning clear and obviates any need to insert, transpose, or invent any other language or limitations that Congress did not include. Further, no extended preemption analysis is necessary. 15 U.S.C. 9058 changes nothing about baseline Iowa landlord-tenant law, but instead applies only to a self-selected class of federally connected landlords who happen to do business in Iowa. This court has never struggled to harmonize federal...
Federally connected, I mean, it could be a house that has a mortgage on it that is covered by and has FHA mortgage. I mean, that's basically the vast majority of houses. If one of those houses is in the rental market, it's covered, right?
Any federally backed mortgage would certainly trigger the protections of the CARES Act, would certainly trigger the notice requirement we're talking about today. But again, Your Honor, those landlords are in a quid pro quo relationship with the federal government. In exchange for being subject to that notice requirement, those landlords receive substantial benefits as borrowers. Lower down payments, more favorable repayment schedules, more favorable terms to avoid default. Any landlord in that situation has opted into that situation, Your Honor.
Subsection C, specifically subpart 2, there is incorporated in it only one other section from any place else, and it is subsection B. And so when it refers to the tenant, why isn't it referring to the tenant in the only subsection that it references, subsection B?
Your Honor, I believe your question concerning 9058 sub A to my colleague on the other side sort of addressed that same issue. The tenant refers to the tenant of a covered dwelling. This notice requirement is triggered when there is a covered dwelling. A covered dwelling necessarily has a tenant. So when we say the tenant, we're referring to the tenant of the covered dwelling. If there's no tenant, there's no tenancy, there's no notices to give. So looking back to 9058 sub A and that definition of covered dwelling, I believe would...
I mean, B just incorporates that definition or those words from sub A. Subsection C only refers to sub B. Why shouldn't we just look at sub B and look at tenant there and apply the 120 days?
And I think, Your Honor, if we look at 9058 sub C, because there is no temporal limitation in terms of an end date. There is no temporal
Well, you started off with, it's clear with the structure, and I know we don't have to rely or can't rely solely on titles, but you want to talk about structure. Everything about this entire chapter, this United States Code subchapter 3, Part A, the section itself, everything screams of emergency. That's why they have those dates on there. So doesn't that have some power?
I think it doesn't override what is plain and unambiguous language, Your Honor, and it doesn't override what 5 different state appellate courts.
Ambiguous that those things are under a chapter entitled for coronavirus and emergency and temporary and stabilization, isn't?
The use of the word temporary in the title may give some indication of congressional intent, but the Supreme Court in and Your Honor, the Supreme Court in Yeski, 524 U.S. 206, made clear that titles of statutes cannot limit the plain meaning. So if we have
Structure, and we're going back and forth here, and I just think that is part of the structure, isn't it?
Your Honor, to the extent the court is inclined to consider that aspect, I would draw the court's attention to the ES in CARES, economic security. Regardless of whether the court believes the biological impacts of the pandemic are going on, I think it's plain from the fact that thousands of people are at risk of eviction across this state every day, that the economic effects of COVID, the economic effects of the pandemic are still in play.
This was enacted in March 2020. Let me ask you the question I promised I would ask you, which is it your position, Mr. Bigsby, that this applies to any kind of default? You know, a tenant is running and operating criminal activity in their apartment. The tenant is creating a safety hazard for the other tenants. Is that your view?
Well, certainly, Your Honor, the 2 cases that are before the court today are both non-payment of rent cases. And to get to Justice Waterman's question in the previous portion of the argument, there is some split of authority as to how other state appellate courts have decided that question. If we look at the plain language of the statute, I would agree with Your Honor. There's nothing in that statute that limits it to non-payment of rent.
Language and we're consistent, it would have to apply to any kind of a default, right?
That would be a consistent reading, Your Honor.
You said that other courts have followed that path, correct?
Correct. So there are 5, sorry.
Has anybody gone to Congress and said, why don't you fix this?
There have been congressional attempts to change the language of 9058. I believe there were 2 as of two separate attempts as of today. I don't know what.
Let me clarify. I think I want to make sure. My reading of those cases is that except for one, the appellate cases have said it applies only to non-payment of rent. Is that the way you read those cases? There's one.
Those are the cases I'm aware of, Your Honor.
One of the Washington appellate courts that says, look, it applies to everything. But you agree that that's kind of an inconsistent reading, right? To say that it applies only to non-payment of rent, but then on the other hand, to say that it applies permanently, that's kind of an inconsistency, right?
If we're looking strictly at the plain language of the statute, the court could certainly reach that conclusion. Obviously, other states have their own residential landlord-tenant schemes that I'm.
The fact that courts have split on the question, is it limited to non-payment of rent, isn't that itself an indication of ambiguity?
It could be an indication of ambiguity were the cases before the court anything other than non-payment of rent. So I don't know that the court needs to reach that question today.
The courts do, if we accept your interpretation with the 30-day peaceable provision, aren't they in an impossible dilemma?
Not at all, Your Honor. And a large reason I would say that is because of the wisdom of this court. From the March 2021 supervisory order issued by this court, directed trial courts to construe, to harmonize 9058 sub C with 648.18.
Time, and then we undid all of our orders. We said, okay, those are done. And if, as Justice McDermott said, if there was something we actually liked that we did, for example, some remote proceedings, we entered new orders or did new rules. We didn't just continue to throw them and say it's still in place because we have an old COVID order out there. Isn't that different?
Well, from a practical perspective, Your Honor, I would say as someone who was a magistrate at the time this was enacted, as someone who now sits in FED court essentially every week, it's from a practical perspective, I don't believe there's any real issue harmonizing that, in part because trial courts have adopted the practice indicated in this court's supervisory order.
Has it been any part of the record? How much of our state, because this has been going, I think this happened 2 years after that moratorium would have ended. Is this the normal practice out there, or are people doing the Iowa 3-day notice business and 30 days peaceable possession?
I would say different landlords certainly have different interpretations of the law.
Interesting. Are there any others out there? Is this how our state's doing it now?
I would say it's certainly typical of my experience, Your Honor, just speaking anecdotally. I don't believe there is the practical issue with 648.18 that the other side has raised in this case. And there are certainly other 30-day notice requirements that this court or the Court of Appeals has addressed. Thinking back to, I believe it's pronounced a HEPA.
Your interpretation, if the 30-day notice requirement extends beyond non-payment of rent and to include things like a safety violation, let me give you this hypothetical. Before the Blackhawk Hotel was beautifully restored, it was rented out for apartments, one of which included a meth lab that caused a fire that led to the evacuation. So under your interpretation, the landlord would have to give that tenant running a meth lab that...
Lord's attorney, I can't speak to that.
That really did happen. Can you answer that? What are you proposing that what you're asking us to do today? How would that fall? How would that play out in Justice Waterman's example?
Your Honor, to be clear, what I'm asking for today is to affirm the ruling of the district court, which did not address the question of whether this applies to cases outside of non-payment of rent. As I've said, I don't believe the court necessarily would need to reach that question. However, in that case, I would encourage the landlord to pursue any and all available remedies. 648 is not an exclusive remedy, Your Honor. Going back to 648.18 and the 30-day peaceable possession provision, this court has never struggled, the Court of Appeals has never struggled, trial courts have never struggled to take existing 30-day notice requirements. So even before the CARES Act, certain federal regulations require 30 days notice prior to proceeding with an FED. Even outside of the federal scheme, if we look at Chapter 562B, which deals with landlord-tenant relationships as to mobile home lots, there's something contemplated in that chapter, what I would call the 14 30-day notice, which if there's a lease violation, a landlord can give a notice giving the tenant 14 days to cure, and if uncured, then 30 days to vacate. Certainly there are 30-day notices even within Iowa law. That's never stopped in any court from harmonizing those statutes with 648.18. I don't believe the 30-day notice requirement in 9058 sub C would need to be any different from those.
Can you address the Nebraska case, the concurrence by Judge Papek in applying the federalism canon? Is that a canon we should ignore?
Well, Your Honor, I think what I would say to that, I would first say that the Nebraska Supreme Court didn't reach these issues that are before this court. They I believe, abstained on mootness grounds as possession had already been turned over. The federalism canon, again, I don't think there's an issue with preemption. I don't think there's an issue with a conflict that arises from federalism, simply because 9058 sub C is only changing the requirements for landlords who have opted into that relationship with the federal government, Your Honor.
Disagree with you and conclude that the statute is ambiguous. In that situation, aren't we obligated to apply the federalism canon and the presumptions against preemption?
I would say, Your Honor, if this court were to conclude that the statute is ambiguous, I don't believe this court has any independent authority to narrow the statute. Thinking to the Supreme Court's Lomax case, fairly recent 140 Supreme Court 1721, if the breadth of the law is set by Congress, a court interpreting it can't.
Ambiguous, shouldn't we favor the interpretation that avoids preempting the Iowa 3-day statute?
Again, Your Honor, if this statute failed on preemption grounds, it would have been void ab initio. We're coming up nearly on 5 years. No one has raised the issue of preemption. We're certainly beyond the 120-day moratorium period that might.
It was void during the 120-day period that was valid congressional emergency legislation. The question is does it extend beyond that? And if ambiguous, then don't we have to apply the presumption against preemption?
I don't believe so, Your Honor. And I would encourage this court to review Horizon Homes v. Nunn, which I would say is sort of the controlling precedent in Iowa as to whether federal regulations such as 9058C would preempt Iowa landlord-tenant law.
Should analysis apply here if this were viewed as a spending clause power or a condition versus a commerce clause power?
I don't believe it would need to change this court's analysis. Certainly, with the caveat that the district court did not address any constitutional arguments, I think both the spending clause and the commerce clause would be valid bases for Congress's authority to enact 9058C.
Does Congress have the authority to enact 9058, however broad it is? And I don't think Mr. Weinhardt's challenging that. At least today he isn't. So then the question is just how far does it extend? And that's where the potential canon against preemption comes in, especially in a traditional state and local law area, right?
And Your Honor, looking back at the statute, it does not have an end date in 9058 sub C. So as to how far it extends, I would say that's certainly a question for Congress. Anyone affected by that statute certainly has a remedy in the political process there. But looking back at preemption, looking back at Horizon Homes v. Nunn, I would also encourage this court to view the requirement at issue here, the 30-day notice requirement, as certainly not novel within the scheme of federal housing regulations, and extremely modest compared to what this court upheld in Nunn. In Nunn, there was an issue as to whether a landlord is required to provide good cause for failure to renew a lease. Iowa law doesn't require good cause. The federal scheme that was at issue in Horizon Homes v. Nunn did require good cause. For reasons that I believe are directly applicable here, this court concluded that the scheme at issue in Nunn did not present a conflict with Iowa law. So I would essentially offer, Your Honor, the extra notice period here as simply the cost of doing business for these landlords who have chosen to participate in these programs.
Very indirect. It can be, that you have a mortgage, an FHA mortgage, which a huge number of homeowners in this country have. I had one for many years, right? I mean, that's a Freddie Mac or Fannie Mae apartment building. That's a huge number of apartment buildings, right?
Your Honor, and even if this court were to characterize it as indirect, it's certainly not accidental. Any landlord participating in these programs, including the federal mortgages, they didn't sign up for their mortgage by accident, Your Honor.
Right. Private mortgage, and then it just happens to say, Fannie Mae financing or guarantees or FHA guarantees, whatever it is. Yeah.
And certainly the landlords in that situation are receiving the benefits of that relationship, Your Honor. Again, I would urge this court to consider from a preemption perspective that Horizon Homes v. Nunn is the standard here. Certainly, in their briefing, MIMG raised the specter of the Alabama Association of Realtors case from the Supreme Court. That case was not a preemption challenge. It was a challenge to whether an administrative agency had the authority to extend the eviction moratorium. But there is language in that case that I believe is directly applicable here. The court in Alabama Association wrote that we expect Congress to speak clearly when addressing matters of vast economic and political significance. I don't know how much more clearly Congress could act other than writing a law and passing a law. Mr. Weinhardt has said that this was done quickly, but certainly, as Justice Mansfield pointed out, it was within Congress's authority to do so. Congress declined to attach a sunset date to that provision. This court, any court interpreting it, the 5 other appellate state courts that have interpreted this case, have all presumed that that omission is intentional. And that's what we're here asking this court to do. MIMG is asking this court to deviate from the path taken by our 5 other sister appellate courts. That's simply a leap that is of no legal basis and certainly unnecessary for this court to do. If there are no further questions, I would ask this court to affirm the ruling of the trial court and conclude that the notice requirement in 9058 sub C has not expired. Thank you.
Mr. Weinhardt.
Thank you, Your Honor. First of all, Horizon Homes does not help legal aid here. In Horizon Homes, the discussion of preemption was both an afterthought and it was dicta. The thing that was allegedly conflicting there was not a state statute, but it was a common law presumption against perpetual leases. Justice Laverado's opinion found that the common law presumption did not apply to the federal regulation that was in question at all. Therefore, there was no conflict to resolve and no preemption issue. What was written about preemption after that did not add to or have precedential effect. But even if it did, the weight of that very plain regulation, as opposed to the mess of a statute we're talking about today, versus a common law ancient presumption, made that one an easy case. Horizon Homes did recognize, though, the principle that we've been discussing, which is that in order to find presumption, you have to have a clear statement of congressional intent. The wrestling around that we are doing with whether C1 does or doesn't reach non-payment or reach beyond non-payment of rent, the wrestling around that we're doing about how do you fit this under the construct of emergency legislation and the name of the section is temporary and so forth, how do we work with all of that? At minimum, all of that creates the ambiguity that falls then under the both the Alabama Association, but the Altria Group case that we cite, and many, many others, both state and federal, that say that when there is a doubt about the meaning of the enactment, you construe that doubt in the direction away from preemption. And I think that that's the case we have here.
Which is the preemption analysis. To me, it seems like the scope of the law has already been determined by Congress in the way it defined covered dwelling. And so anything that fits the definition of covered dwelling falls within the scope of the federal law. I mean, they've kind of limited the field that way. This isn't a law of general applicability that applies to all landlords where we do a traditional preemption analysis. So why isn't that enough? Congress has told us what covered dwellings are. It's not a preemption issue. It's probably a federal largesse issue, which, you know, it is what it is.
The reason is that statutes have geographical scope. They also have temporal scope. And the issue here is about the temporal scope of the statute. Did Congress, while conceitedly deciding to preempt state law during the moratorium and for defaults that occurred during the moratorium, did they also intend to continue to preempt state law after those events were in the distant past? And that is where the ambiguity comes, and that temporal scope, I think, is one that this court can and should construe away from preemption rather than in favor of it. By the way, the case that I was mentioning about this court's authority to construe federal law for that purpose is the Top of Iowa co-op case cited in page 18 in the footnote in the landlord amicus brief. The one other thing that I will talk about momentarily is, Your Honor, Madam Chief Justice was asking, well, what's actually happening out here in the field? And the court's information about this is only going to be anecdotal, but what we would submit is happening is that there are different courtrooms with different magistrates, and they confront this peaceable possession versus the 30-day thing, or they confront the question of, do I think in my courtroom 9058 still applies today? And they all kind of try to find their own way of making peace with what we all believe is a messy situation. What we're asking for here is a reversal that clears up the law so that we don't have to fight through that messy situation at all. Unless the court has any other questions, my request is that the judgments in both the Miller and the Williams cases be reversed, and that the court hold that 9058C1 does not any longer require a 30-day notice period for residential evictions in Iowa, and that we are restored to the 3-day FED notice period that we all grew up with. Thank you.
Case of MIMG versus Miller, as well as MIMG versus Williams, is hereby, or both of them are hereby submitted. And the court is adjourned for the afternoon.